Okay, good evening, everybody. It is exactly 6 o'clock, and we're going to get started. We've got, I know our special guest has a hard out at 7 o'clock, so we want to get started. I do just want to go over a few things. I'm Sarah Brown. I have spoken with a lot of you on Facebook. We've gotten that together, me and a little help from my friends, the Grahams and Melinda Morris are helping me on Facebook and trying to get information out to you as best we can. I do have a sign-in sheet. Blake has it in the back. So if you haven't already given us your information at the last meeting, I know we have a lot of new people here tonight, please sign in so we can add you to our email. And then join that Facebook group if you're on Facebook so we can keep you posted that way as well. Tonight we have Jordan Walker. He is an attorney with Seaver, Walker, and Paget. And their Georgia office is in Alpharetta, Georgia, near Atlanta. And he is licensed in Georgia, Illinois, Indiana, Texas, and Missouri. We're only concerned with Georgia. And he represents landowners only. So I think that is important, and I know I'm, for one, pretty excited about that. So anyway, he's going to talk to us, give us some advice, and then hopefully we'll have some time at the end of his presentation for you to ask questions, and then we will, have a few other things after he leaves. So I'm going to go ahead and quit talking and let him take it from here.
Thank you. Thank you so much, everybody, for having me here today to talk to you about something you probably don't want to happen to your property, and that is the construction of this transmission line by Georgia Power. I'm just going to jump right in. This is what we're going to be talking about today. Real quick, just a little more background about our firm and what we do. Again, we are eminent domain only attorneys, and this is the only area of law that we practice at our firm. If you go to our website, you're not going to see personal injury, bankruptcy, med mal, anything like that. You're going to see nothing but eminent domain. This is the only area of law that we practice, and in fact, it's the only area of law that I have ever personally practiced. And that's going on 15 years, and so we've accrued quite a bit of knowledge and experience about how these projects work, how these companies operate. We obviously know the law and what you're entitled to under Georgia law, and that's the law is what the law is. But we have, down in the dirty communications with energy companies. We know how they work. We know how their contractors work. We know how you guys might know how their contractors work at this point, and we know what their goal is and what they want to do and how they do it. So my job today is to relay what we've learned at our firm, dealing with these cases, not only in Georgia, but across the country. And yes, we're only gonna be talking about Georgia today. A little bit more about our firm. We've quite a bit of work, quite a bit pipeline and power line work. Utility work is becoming a large part of our client portfolio, I guess you could say. It's always been a part of our client load is dealing with utility projects, but more recently, these gigantic transmission lines, and when I say recently, I mean very recently, are popping up all over the country, especially in Georgia, especially in Indiana, especially in Texas, and others across the country. Those are not the only states. And the reason they're being built is to meet the demands that are being created by data centers, which of course is driven by AI. So it isn't a coincidence that with a heavy investment in AI and that type of infrastructure comes the need to transmit energy to these locations, these substations, to meet this capacity. So I don't want to get it twisted. This isn't, these transmission lines are not being built, in my view, to help out the general populace so much as they are being built to satisfy large companies investing in AI. Unfortunately, that commentary doesn't do a lot. It isn't factored into the law. The fact that ultimately the purpose of these lines is maybe not necessarily as commonly enjoyed as they may present it as, that is not an argument against them. It is merely an unfortunate reality that we find ourselves in with these lines being built. So a lot of pipeline cases, a lot of power line cases, and like I said, because they're being built so much recently, we are learning even more than we previously thought we knew. And that includes, as stated, 50 years of combined experience. That includes, of course, my experience and my partners as well. Again, what we do, road projects, pipelines, power line takings, anytime somebody can take land, we like to be there to help landowners out. So let's talk about eminent domain real quick so we have a baseline understanding of what we're dealing with. Eminent domain is the power of an entity to acquire private land and put it to what's referred to public use. We already talked about the reason for these transmission lines. You might say, hey, that doesn't sound like a public use. I would agree with you. Unfortunately, the law does not. These transmission lines transmitting electric energy from one place to another, they are de facto public uses. So if you plan on showing up at court and say, this is not for a public use, this is only for private companies, so on and so forth, you are not likely to win that argument, unfortunately. The law gives a lot of deference to companies like Georgia Power, like Georgia Transmission. These utility companies, semi-private companies, have this ability to condemn that is delegated to them through statute under Georgia law. So because they have this power, this ability, you saying no to them from now to eternity may not necessarily accomplish what you want, because they have the ability inherently to take you to court, to sue you, to file a lawsuit against you to get your land for the purposes of the project. That is called eminent domain. Again, it is a reality that we live in. When people think about eminent domain, if they know what it is at all, they often think of GDOT, Georgia Department of Transportation. They think of their county. They think of a municipality taking land for a road project or for a library or whatever public use is needed. And that still happens, of course, but the new eminent domain are utilities acquiring private land for these purposes now. So they have this ability, but with that power comes responsibility, and their responsibility to you is to pay you just compensation for your property. And just compensation means it isn't up to them, it isn't up to you. If it gets to a certain point, it's up to a jury of your peers. They determine what you're entitled to. And so, and that's if it, of course, gets all the way to the end of the process. So you have that right, and I like to stress that because you're going to be dealing with right-of-way agents here in a bit, if you're not already, and they like to say a lot of things. A lot of them are false. And one of the things they like to say is that if you go to court, you're going to get nothing, or you're going to get less, or you're going to get what we say you get. I mean, that might happen, but they don't get to determine that. The jury determines that. And you have your right in court. You have your right to the day in court. You have the right to present evidence, just like they do. And if you so choose, you can put it in your peers' hands to determine what you're entitled to. So you always have that right. That's guaranteed by the United States Constitution, and it is guaranteed by the Georgia Constitution. So that's not going anywhere. And then we can go to the next one. So let's talk about this project a little bit more. It is a 500 kV line. It's 45, I think it's closer to 60 miles, actually. I don't know if that's correct. I think it's closer to 65. And you might be wondering, what does 500 kV mean? I have no idea what these numbers and letters mean. 500 kV refers to the voltage, 500 kilovoltage, 500,000 volts. And as far as transmission lines go, that is very high. As an example, we do this a lot, like I said, and the only time I had ever seen a transmission line above 345 kV was when it was out west. These huge transmission lines that cross Bureau of Land Management lands, huge swaths of lands with nothing around. They put 600, 700 huge transmission lines. Nobody really cares. They're out in the middle of nowhere. whether it's 345 or 700, it doesn't really matter. What's happening now is we have these high voltage transmission lines that are usually reserved for isolated areas away from population centers are now being brought to population centers. And it's not just here, it's Atlanta, it's Macon, it's all over the state, it's all over the country. And when I learned about these projects, I couldn't believe it. I couldn't believe that they were building these gigantic voltage transmission lines in the greater Atlanta area. I mean, it's unheard of, but that's where we're at. That's what's going on. And that's a big deal because with that voltage comes an impact on your property's value, to say the least. And so this is a kind of a new territory for a lot of people. It's probably a new territory for Georgia Power, not traditionally building these gigantic transmission voltage lines in areas where people live. So with this kind of new type of acquisition comes a lot of different issues that aren't normally brought up in these huge 500 kV lines that, again, are usually away from people. Now they're putting it close to people, and people don't want to live close to power lines. It's pretty much as simple as that. So how does that affect your property's value? We will get into. But that is the big issue that is being raised by this specific type of line. So with regards to this project, my understanding is we are early, and it's early from my point of view. It might not be early for your point of view, but I believe we're in surveying. I believe that there's surveying going on, maybe some soil boring, surveyors coming out, talking to landowners, wanting to check out the property to do their surveying for the line. That is the beginning of the process as we see it. Surveying is the first kind of on-the-ground visualization you'll see of them there, putting something on your property or doing something on your property. Once the surveyors come out, it isn't a done deal by any means, but you're inching towards land acquisition. And after land acquisition comes construction. So if you have a surveyor out, or if they haven't been out yet, I assume they'll be out eventually. One thing I want to touch now, because I'm sure it's something you guys are curious about, do they have the right to survey your property even though you don't give it to them? And the answer is they do. Georgia law permits surveying contractors from condemning authorities, which Georgia Power is a condemning authority. So they have this right to do it. Some folks, a lot of folks, don't like that. I agree. Unfortunately, if you don't give them surveying access rights, they will use the court system to get an injunction to access the property. Now, if that's a fight you want to launch, by all means. I can just say that the unfortunate reality is that surveying is pretty clear, as the law states, it gives them the right to do it. And you might be wondering, when the fairness comes in this process, and there's not a ton of fairness. Really, the only fairness you're going to get is just compensation. Everything else is designed to make it easier for Georgia Power and condemners to take land. So, back to the schedule. They've surveyed. What happens next? Well, eventually, after they've surveyed, you're going to get an offer. If your property is impacted, you're going to get an offer. They're going to issue you a compensation offer for the easement they want on your property. And that actually brings up a good point I want to touch on. What is an easement? Most of you might know what an easement is. A lot of people don't, which is perfectly normal. Easements are conveyances, land conveyances, that convey the right to do something on your property to a specific entity or person. So unlike deeding your property, if you sold your house to somebody, you fee simple title, you convey the deed, you give it to somebody else, they own the property. Easement, you're deeding the right to do something on a certain area of your property to an entity, in this case, Georgia Power, that being the right to build a transmission line. The problem is, what we run into, is that what is often presented to landowners in this easement document and what is verbally told to landowners about this easement document is not always reflected by the easement document itself. As a matter of fact, most of them are very poorly written. and they are broad in Georgia Power's favor. And I'll give an example. We represent a landowner, a different project, another gigantic transmission line. And they said exactly what I'm sure they're going to say to you is, hey, we want to build this 500 kV line. Or they might leave the voltage out. We want to build this line, but we're only going to do this. We're only going to build one transmission line, and that's what this easement says. And I read it, and it did not say that. It said they have the right to put as many lines as they want, as much voltage as they want. They have the right to sublease their easement rights to fiber optic cable companies, AT&T, for example, so that they can then come in and run their communication lines in the easement. And then, oh yeah, by the way, we're also going to do some distribution lines on the outside of the easement. So in the middle is a huge 500 kV, and then on either side of the line are other distribution lines, smaller voltage, ones you see around town generally, but still, they're also going to be there too. So you have unknown numbers of amounts of voltage going through this easement, but they only told the landowner that we want to build one line. I wouldn't be surprised if they do the exact same thing here. In fact, it seems I was just visiting another landowner's property up in Fayetteville, same thing, and I rode around on his property on his gator, and he was surprised to see even more survey stakes and flags out from the last time he had done it a week ago, because all these additional stakes are out there. Well, what are these for? And I said, these are for the distribution lines they want to run. This is for the additional lines they want to run that they didn't tell you about, that they're not going to tell you about, because the easement already gives them the broad right. Why would they tell you? You signed the document that said they can do whatever they want. They can do whatever they want. So it's important, and we'll get into here in a bit. The compensation is one thing, of course, but the easement language is also incredibly important. They go hand in hand. One contributes to the other. How broad is the easement? What rights are you giving to them? What rights are you relinquishing to on your property? Obviously a big deal. And again, we'll talk to it a little bit, but I want to go back to the schedule. So you've got your offer. That's where our firm gets involved. We will evaluate your offer for free. We do that for everybody. So if you have an offer, you just send it to me. I'll look at it for free, give you my thoughts. Let's say a deal cannot be reached. Well, Georgia Power needs to build this line, so they need to get the land. So that if a deal can't be reached, they will file their condemnation. They will file their eminent domain lawsuit against you to get the land. At that point, there are two main issues of the condemnation. There's one, Georgia Power getting access to the land to build the project, and two, your compensation. The first part is met by a special master hearing, which a special master is designated by the court. They come up with preliminary compensation. The Georgia Power deposits that preliminary amount. You or they appeal that amount to a jury. The jury determines final compensation. Final compensation is what you get. That is a 30-second overview of the condemnation process in Georgia for power lines. Not all cases reach eminent domain. I would say for utility cases, in my experience, most of them don't, but some do, and you need to be prepared for what that means and what that could possibly entail. So, that is the eminent domain process, again, from a very curtailed version, abbreviated. But so if you get to that point, that's what you're looking at. And then finally, where you're at right now, we're at the surveying. I believe we're at the surveying stage of the process. And as we put on the slide, oftentimes pre-condemnation is when you have the most leverage as a landowner. Not always, but especially if there's a group of folks, that is where you can really maximize your leverage and get more of what you want out of this, is in the lead up to the condemnation, where you can really turn the screws to them and get exactly what you want in your easement and from a compensation perspective. So, I touched on this earlier. There's two components: easement, compensation. Easement, again, that's the document. This defines everything, and guess what? It doesn't go away. These are perpetual, permanent easements. It will always be on your title. unless they release it or there is abandonment language that requires them to release it in the easement. But it's fair to assume, and you can drive around, there's transmission lines that have been around for a long time. It's fair to assume that this is going to be on your title forever. And that means if you sell it, it's going to be there. If your kids inherit it, it's going to be there. If they don't build it, it's still there. If you sign the easement, it's on your title, and it does not go away unless it's relinquished or removed from the title, which generally they don't make a habit of doing. So a lot of people, they have their property, and maybe they don't necessarily care for themselves about what's going on. I think a lot of folks think about their kids inheriting it or what the property is going to look like down the line. And maybe it's something that won't affect you personally, but it might affect your kids or your grandkids and what they want to do with the land. So it's important that your kids don't wake up and read the easement one day and see that, oh, Georgia Power has the right to put 10 transmission lines across my property, and they have the right to unfettered access across it. They have the right to put pipelines in or whatever they want. So making sure the easement's correct isn't necessarily for you. It's more for who's going to get the property next. And when they take that property, they aren't dealing with the negligence or not negligence, but the lack of attention you gave to the easement. They're realizing what you failed to do. So protecting the easement, making sure it's properly drafted. For a lot of people, it's the most important thing to be concerned about. For some people, it's the second most important. Regardless, it's important. So, and again, what they tell you, verbal promises, they don't mean anything. What they told you in the living room in 2026 means nothing to your property in 2029 when they're installing their second transmission line. If the easement says they can do it, and they will do it. So the first part is the easement. The second part, of course, the compensation. And compensation, of course, it just as they do a poor job drafting the easement, that's on purpose. They also do a poor job in offering compensation to landowners. That's also on purpose. Both of these documents that they'll present to you, the compensation document, the easement, they're going to be insufficient. I can virtually guarantee it. There's a reason our firm exists, and it's not because Georgia Power is great at compensating landowners without us. So with the compensation, it's important to understand what you're entitled to under the law. A lot of people think you just get whatever you want, and you just say, well, I want this because that's what I want. It's a good place to start, but it's important to remember that, the law, eminent domain law, narrows what you're entitled to certain aspects. So when you're negotiating with them, you need to kind of put it in a frame that they can understand, and they understand what's compensable and what's not. Their attorneys are telling them that, just like I'm telling you. So it's important for you to understand what's compensable and what's not. The big issues, you want to make sure that the price per acre is proper, and I don't like to focus a ton on that unless we're dealing with commercial property, because they want to have that conversation. If you have a 5 acre acquisition, and they're offering $10,000 an acre, and you say, well, no, it's worth 12. You're playing into their hands, because that's a difference of $10,000. They'll have that conversation all day, because they're not worried about another $10,000. What they're worried about is you coming to them and saying, well, actually, this is going to devalue my the entirety of the property by 20% or 30%, because those numbers get a lot higher much quicker than talking about price per acre. So while it's important, I wouldn't get hung up on it unless you're dealing with commercial land values where they're offering agricultural or rec land. So it's important that you get a good price per acre. You're entitled to crop damages, timber damages. You're entitled to ground restoration damages. You can get paid for these ahead of time or after the fact. This is restoring the ground. It's important that you at least get paid for that, because they don't, also if it's not in the easement, they don't do a great job of keeping the property restored unless they have to. So it's good to both have language that requires them to do that and get you paid for any potential issues that you might face. Especially getting it paid up front, because going after these guys, after it's already in, unless you're suing them, good luck getting their attention, especially to ask for more money. So it's better to get this kind of thing paid for up front. And that's something that we obviously do. And then again, the two big issues that I see, the loss of value to the remnant, the remainder, that's a big issue. We talk about it a lot, and it's how does this transmission line affect the rest of the parcel? You have a 40-acre lot. They're putting a 5-acre easement on it. How does this 5-acre easement affect the other 35? And how it affects it depends on what type of property it is. Is it bisecting it? Is there a house involved? All of these things come into play. They are the biggest source of difference of opinion between the landowner and the utility, is the impact to the rest of the parcel, something they do not want to talk about, as previously stated. And then finally, business losses. This is actually uniquely Georgia, a uniquely Georgia law. If you have a business operation on the property and it's being destroyed, you can get those losses recovered. That is not something that is the case in many other states. So I guess one silver lining is that if you do have a business, you can get business loss recovery. Wow, that is a mess. Okay, these were issues that to look for on the easement. Issues that we see a lot with problematic clauses, problematic wording for the easements. Unfettered access. They love to put this in. They can go wherever they want, access wherever they want, come in from the road, come in from the middle of the yard. They love putting that in there. That gives them the right to just come in whenever they want, wherever they want. They love to leave out the restoration, the requirement that they restore the property. If given the opportunity to not restore the property, they absolutely will take that opportunity, and that includes, fixing erosion issues, terraces, you name it. Anything that the ground is uneven, needs to be leveled, all of that. You need to make sure that they have to restore it. Liability, this is a big deal. A lot of times they will disclaim liability for anything that happens on the easement, and they'll shift it to you. Or you'll be maybe it won't be shifted to you, but you won't be indemnified is the term, wherein they protect you if, somebody wanders onto the property, climbs the transmission pole, falls, and sues you. It's important that you have a clause in the easement that would protect you from any liability. As we see it, they don't generally include that. So you need to make sure that that's in there too. So you're limiting your liability, and they're protecting you, in fact, if there's anything that happens. We already talked about access. No future damage clause, that's another thing. Because they'll come in down the line and do maintenance. And if they damage a fence or something like that, there needs to be something in the easement that requires them to pay you for that. Ongoing damages, they have to be liable for, because they oftentimes like to disclaim liability for future damages as well. And then the big one, or one of the big ones, the right to add more lines. The easement is very often, it starts with the right to add, right to build a transmission line. The right to add to the number of is usually the language they use. And that right there gives them the right to add as many lines as they want. And that needs to be taken out immediately, because otherwise they will absolutely seize on that and use it as much as they can. Okay. I'm going to speed up a little bit so we get to questions. This is just compensation. We already kind of touched on a lot of this. Ultimately, I think the important takeaway, what's the before value of your property? What's the after value of your property? The difference between those two numbers is your just compensation. It's as simple as that. What is it worth before? Now there's a power line. What's it worth now? And it's kind of hard to come up with that number, especially if you're not an appraiser or an eminent domain appraiser. The good news is that we're not appraisers, but we know how these cases go. We know what the experts generally say. And so we can get a feel for a rough understanding of where the case is going to head, what the appraiser is going to say, what the pros and cons of the case are, to come up with a proper number that you should be accepting. I think that's the best, most important takeaway from this. That, in addition to demanding the jury trial, you get it as a matter of right, but you should respond to the lawsuit when it happens with the demand for it. So I talked about right-of-way agents, and again, I'm gonna speed through this a little bit. So right-of-way agents, their job is to sell you on the idea of you selling them your land. They are salespeople. They get paid to lock up your parcel. So when they show up and they issue you an offer, whether they're your best friend or your worst enemy, they're going to use these tactics to get you to sign that document. That's what their job is. That's what they're paid to do. And that's what they're going to try to do when they are ready to try to acquire the land. And because they have a job, they do this all over the country, right-of-way contractors, fairly common. I know several of them. They do the same thing on each project. They make it seem like they're giving you a good deal. Say, hey, look, we're giving you more than fair market value. You should take it. Saying that they'll pay for timber damages up front. Wow, how considerate. You did something you had to do anyway. Lowering and raising offers, they like to do that. They like to make it seem like it's going away. Or you're going to lose, or you're going to go to eminent domain and get nothing. Or if you don't take this, we're gonna lower it. All these things, these raising, lowering, it's manufacturing leverage to their extent. You know, they want to get you in a tizzy, have you do a quick decision, scare you into something. That's their job. They want you to do this. They want to either ingratiate themselves, scare you, get you to sign the document without too much stress. So they'll do that. Bonus payments, again, same thing. If you take it now, we'll give you this. If you don't, it's going away. I got news for you. If they offered it once, it's always there. It doesn't go away. It's there from the beginning. So don't be scared when they start employing these tactics. Verbal promises, again, it doesn't mean anything. If they say, don't worry about it, we're only going to do this, we're only going to do that, your response should be, talk to my attorney. But your second response should be, put it in writing. Put it in writing. Put it in the easement. Put it in an email. And that's one thing that I always advocate. When you're talking with these folks, the right-of-way folks, in-person conversations, phone calls, establish a record, talk via email, text. All communications are all via writing. Email is the easiest way to do it. You want to talk to me? Let's email. What are you willing to do? Put it in an email. And you'll see them clam up a little bit. They'll say, no, let's have a conversation. Let's talk. No, legal documents there has to be a writing. That is a hard and fast legal rule that you learn 1L in law school. Property conveyance needs writing. Verbal promises mean nothing. So it all depends on what that easement says. And that goes for compensation, of course, as well. If they want to offer you something, put it in writing. They love to. I've seen them. They'll write down a number. They'll take it with them. You know, they do all sorts of things. It is what it is. They're doing their job. But just I like to advocate for landowners to kind of see through it and see what their end goal is and what they're trying to accomplish. Okay, we're almost there, folks. Okay, what to do when you receive do's and don'ts. When you receive an offer. Again, we already talked about this. Insist all communication go through email, paper trail, create a paper trail. What I say, and I just instruct landowners, I say, when they reach out and they say, hey, we want to give you an offer, or we want to talk to you, send it via email. And then when they send it, say, thank you, I'll review and get back to you in a week. And I know it's specific, but the reason why I say that is that you're demonstrating to them that you're not ghosting them. You're not just leaving them in the lurch. You have their attention, at least somewhat. But you're also giving yourself some time from them to review what is being presented. So you have them send it to you. You say, thanks, I'll get back to you in a week. And they should give you a week. The issue, you can't say a month because they'll keep calling you. They'll keep bugging you. You can't say 4 weeks. They'll want to stop by. They're going to be around. When this offer comes in, they are always around. They're going to stop by. They are going to be hounding you unless you let them know you're paying attention and you're doing your due diligence. And so in that week where you have the offer, you're getting yourself a buffer, you send the offer to me. I look at it, again, for free. I give you my thoughts. You decide what you want to do. And then at the very least, you're getting an opinion, you're doing your due diligence, and you can, of course, decide whatever you want to do is what you want to do. At the very least, though, in this strategy, like I said, you're doing your due diligence. Contact an eminent domain attorney before negotiating. You're doing that right now, so you're ahead of the game. Talk to your neighbors. You're already doing that. Read every word of the easement. We talked about that. Save everything they send you, letters, voicemails, anything like that. They have a conversation with you. Write down notes about the conversation. And yeah, I think, but if you don't want to do any of this, always remember that you can contact me and I can guide you through it. What not to do. Don't start negotiating. Don't start just jumping in and start throwing numbers out. That's how you lose. You either aim too low and they take it, and that's it. Or an example is you give a number that comes back to bite you in the butt. Let's say they offer you $10,000. You say, no, I want 60. And then you contact me and I say, wow, you should be getting $400,000 for this. And I go to them and I say, hey, we want $400,000. They say, we're giving you 60. He already said he wants 60. And that travels with you the rest of your case. It doesn't matter if it goes to condemnation. They write it down. They know you'd take 60. It goes to the attorney. The attorney knows you'd take 60. It's very difficult to get over that hurdle if you already tell them what you'd take. So a lot of people want to just jump into negotiations. Not a good choice, at least without talking to somebody first. You're free to negotiate, but at least talk to somebody. Don't hire an appraiser unless you need to. In my view, you don't need to unless you're at litigation. Eminent domain appraising is very expensive. It is money that I don't like to spend on my client's behalf unless I absolutely need to. And in my view, it's not necessary until we need to prove our number. And in my view, you don't need to prove your number until you're at court. So a lot of people want to jump out and get their own appraisal. And beyond them being expensive, you need to make sure you're getting getting your money's worth. Because once you get that appraisal and it's created, it's evidence. And if you get to court, maybe you don't like the number that the appraiser did, that they came up with. It's discoverable now. You get to court, they're going to see it. They're going to see you paid for an appraisal. It said X, and now you want something else. It's not a good look. So, but I think at the end of the day, it's important that it might not be necessary. And again, if you don't need to spend money, why do it? Don't sign anything because you feel pressured. Don't ignore the offer. A lot of people just put it aside, out of sight, out of mind, don't want to deal with it, and then they end up in court. And maybe they shouldn't be at court. Maybe it's a case that should not be an eminent domain. That is a situation you don't want to be in. So, and then this is the second to last slide, and then we'll open up for questions. This is just real quick how we operate. How we operate is the contingency option of these three options. Most people know of attorneys, they have a billable rate. They charge you for the work they do. It's a traditional method of attorney work. We don't really like to do that because how do you know what I'm doing is in your favor? I might just be doing busy work, or I might just be wanting to bill. While how we operate is a contingency fee. And we only get paid if we get you more than what is offered. So if your offer is $50,000 and you hire our firm and we get you $150,000 as example, we would collect a third of the difference. Now, I will say that is our standard fee, the 1/3. That can be changed. It can be lowered depending on how many folks we end up representing on this project. The more folks that we represent, the more economies of scale that we can accomplish, the more efficiently I can do my job, and the lower my fee can be. And we can get into that individually of what we're looking at, but the more folks that are signed up, the lower my fee. But beyond that, putting aside my fee, the more folks that sign up with one attorney, the more leverage you have. If I go to Georgia Power and I say, hey, I got 5 folks on this line, they know who I am, they know what we're doing, so we'll still command respect. But if I go to Georgia Power and I say, hey, we got 40 folks on this line, well, okay, now they really have to pay attention to what I'm saying and what we want. You realize the leverage that your group creates individually. So the group creates leverage as under one attorney, And through my representation, everybody realizes the benefits of that group leverage. Eminent domain is not class action. It is not group claims. Everybody has an individual claim, individual compensation. Property, by definition, is legally unique. So you and your neighbor's parcel, whether they look identical, are legally different. And so each property has different issues. So we can't settle for everybody. We have to settle individually because everyone has individual issues that need to be addressed. So it's not when and if we resolve these cases, it isn't done, on a large scale manner. We still represent individually your interests, your concerns. So I do like to get that out of the way because some people are curious about how that works. Okay, and I'm gonna take questions after this. Once you get the offer, I say that's the time to hire an attorney. Until that point, do your due diligence. You're doing it right now. Talk to your neighbors. You're already doing it. And then bring us your offer. As soon as you get it, you don't even need to call me. You can, but you don't need to. Just send it to me. I'm not going to charge you. We don't bill like that. We already talked about that. Just send it. You can email it to me. You can text it to me. I'll look at it. I'll know what it is immediately. And then we'll set something up to go from there. So that is the end of my presentation. And I'm going to open up for questions. Yes. So the question was, do you know if there's a map of the proposed route? I did some research. There's not. You guys obviously have the internet as well, and know that there's not a ton out there. I haven't seen maps, although I don't know if the group organizers have access to that. Yeah, I would suspect that once we get further into the land acquisition, when the project becomes more realized, I would suspect there's going to be more information online. We're doing these on other Georgia Power projects up north, further in Atlanta. There is information. There's maps. It's not difficult to find out what they're doing with this project, which I think is at an earlier stage than that one. I think as this project gets a little more mature, you're going to start to see maps and more information come out generally. Generally, for these types of projects, it doesn't just stay hidden forever. It becomes a thing that they're proud of. So, yes. Like time or money? Okay, so a timeline for offers. I'd love to have that information because it makes our marketing a lot easier. We can identify. We know offers are being issued, and we can send them out. I would expect. This year, I would expect offers this year, just because they're just going off the surveying schedule. Surveying is usually done, several months ahead of Land Ac. The surveying probably is going to play into their maps a little bit, at least their route choice. That might also be the reason we don't have maps. Is the surveying that's going on right now is contributing to that map creation. So just without having any sort of knowledge about what they're going to do, I would expect this year, maybe the end of this year, you'll start hearing from them. Yeah. No, that's okay. So yeah, the surveyor told this gentleman that they're not going to give you maps, and that tracks. They're not going to divulge information until they need to, and that's any condemner. That's Georgia Power. That's GDOT. They are not great about sharing information about where it's going, what they're taking, until they absolutely want to and need to. They go at their schedule. Unfortunately, it's their project, and they're going to do what they need to do. You just have to respond when you need to. So that makes sense that they're not going to have their surveyors do anything besides surveying. They don't want them engaging in any of that stuff. A, they're not qualified. B, it's not their job. But so that makes sense. You can try calling Georgia Power; they'll probably laugh at you and hang up. But unfortunately, the reality is you'll learn when they want you to learn. And to be clear though, the offer, when you get the offer, it should. I'd be shocked if it didn't. It'll include a map. It'll include a path across your property. So it'll say we're going here. Well, that's what it'll ostensibly say. It'll say, we want 5 acres. Here's the offer. Here's a letter. Here's a compensation sheet. How much acreage they want, and that'll be that. So you'll know when they issue the offer where they're coming across your property. Other questions? Yeah. Great question. The question is, oh, absolutely, very important question. One we get a lot. The question was about taxes. So when they acquire the easement, they have a property right. They have to pay taxes on their easement. You still own the land. So you still own the property. They just have the easement rights on top of the property. You're theoretically responsible for the property taxes on that area. However, you can get that reassessed. So when they do their assessment, you can appeal your tax assessment and say, wait a minute, no, part of this has a power line on it. I don't own 100% of the rights in this area. You need to reassess. You can appeal your tax. If they don't consider the easement in your property taxes, you can get an appeal and review it in consideration of that. So it's a good question. Another good question while we're talking about taxes, because one thing I do like to bring up, the compensation that they're going to give you, one question I get a lot is, what's the taxability of that money? What do I have to pay on it? And we are not tax attorneys, I should state that, but the answer to that question is the land itself is capital gains, as you might imagine. Any damages to corn or trees or any sort of business type, that's ordinary income. Damage to the land, however, ground damages, the soil, ditching, things like that, those are not taxable because they're reimbursing for existing damages or actual damages, I should say. So one thing that's helpful with getting somebody who knows what they're doing is you can structure the resolution such that it limits your taxable impact. You might say, well, why am I paying taxes on something that I didn't want? Unfortunately, the tax man comes for us all. And that includes on these sales of property. Now, you also can do a 1033 exchange, which is a 1031 exchange, but in an eminent domain context. I'm getting really down the road on this. If you want to talk about that, we can. But that is another way to limit your taxable impact on the compensation you receive. Correct. Yeah, for 1033 purposes. Yeah, so you get, instead of a 1031 treatment, you get 1033 treatment, which is more beneficial. Sounds like you probably already know that, though. Yeah. I mean, you can. I don't know if you're going to get much of a response. So you're getting into the purpose of the project, and the purpose of the project would be better litigated at the Public Service Commission level. So the Georgia PSC has some regulating authority. I say some, it's not a lot. And so you would be attacking the underlying need of the project. You would ask them, hey, this isn't needed. Can you give me facts? They're not going to give you anything. They're under no obligation to give you anything. You would have to either get that on your own or get to court and subpoena it. Well, the law requires need and necessity. The way they demonstrate that and the way they'll be able to demonstrate that will pass sufficiency of that the law permits. You know, they'll say we need grid capacity, and say I don't know what to tell you. We got an increase in demand, and we got to meet this demand. I don't know where the demand's coming from. We just got to meet it. That's what they're going to say, and the court's going to say, okay, if that's what if the need is there, if the demand is there, now we know where the demand is actually coming from, but because it's couched in the demand, getting into why the demand exists really doesn't come into play, because it's still serving transmitting electric energy capacity in Georgia. It's grid strengthening, even though we know why it's being strengthened. Well, they're just not going to produce it. You can ask for it, but they're just not. I mean, they produce it at the Georgia Service Commission level. So I haven't looked at the docket on this, but they have. I mean, they have that ability to produce it. I mean, I'm not saying they don't have. They'll be able to demonstrate need if necessary. That's a really tough hill to climb, the public need, especially for transmission lines. It's a tough argument to make, and getting the documents, like you said, they're just not. You can ask for it, they're not going to give it to you. You got to make them do it, and you could maybe do it at eminent domain, but at that point, I'm not sure if that argument's not going to win there either. Well, surveying, you'd be surprised. Surveying happens in anticipation of projects, in anticipation of approval all the time. It's not uncommon for surveying to start before a project is approved. As a matter of fact, it often happens before a project's approved. Sometimes projects aren't approved. It's very infrequent. And I think energy companies, Georgia Power, are fine with that cost of doing some surveying for a project that didn't happen. So just because it hasn't been approved doesn't necessarily, or just because they're doing surveying doesn't mean it will. It just is a standard precondition to any project. That's a good question, actually. I've been. So something I get a lot, why aren't they doing this? Why aren't they taking this route? Why are they taking the route that they are taking? It doesn't make sense. That is something I get quite a bit. Unfortunately, rationality is not in itself an argument. And also, the thing is that they show up and they say, we did all this engineering. We spent millions of dollars on engineers, and they said this is the best path. It avoids wetlands over here. It does this over here. This is why we're doing this path. And it might be nonsense to you. It might not make sense to you or me, and maybe it doesn't make sense. If they have a reason, the deference that they get is enough, effectively. And they say, listen, this is the route we want to take. One of the things that I strongly recommend, and I forgot to say it, I always say, I'm not here to deter anyone from advancing any political interests, as in like talking to your representatives, talking to your, that's why they're there, talk to your elected officials. By all means, go for it. That frankly is probably gonna be the only way you get something changed, is by getting in touch with those folks so they can swing their weight around to do their job. So if I don't want to deter anyone from doing this, is more of like an individual, what do you do when they actually are coming to you to get the property? By all means, demand answers from everybody and anybody. I wish I had them. Unfortunately, I don't. Yeah.
I've got two questions. My first one, just out of curiosity, so when you're dealing with real estate, making an offer, I would imagine that their first offer is not going to be best. In your experience, what would you normally say? I mean, not anybody wants to push the envelope either, but 2 or 3 going back and forth, I would imagine. I don't know. What do you see as far as they make an offer, you say, no, that's not good enough, and they come back again? Is 3 kind of the magic number as far as what you see? Or?
Here's the thing. Every parcel's different, and their offers are different. You know, what they offer you may not be the same thing they offer your neighbor. It probably will be relatively similar because they usually do a, you know, kind of a rough price per acre that they offer to everybody in the same area. But they also, the thing is that with Georgia Power and any utility company is that they don't even, the concept of remainder damage or stigma that's caused by transmission line introduction to properties, they don't even consider it a thing. They won't even engage in the topic. You say to them, hey, this is bisecting my property, I'm gonna lose 20% of its value. They're gonna say that's not a thing. They're gonna say remainder damage isn't real. And you know, whether they believe it or not, it doesn't matter. And how it affects the property, how it affects your property might affect your neighbor's property differently. So it's really tough for me to get into like, well, if they offer this, then you should be here. You know, it's a, yeah. Yeah. So, great question. Where do they get their the question is, where do they get their land values from when they make their offer? Generally, what they'll do, their initial offer will probably be, they'll do some sort of internal broker's opinion of property values in the area, and they'll issue the offer based on that, seeing how many people they can get signed up for the lowball offer. It's just raw land value that they pulled from, you know, a county record book of land values. Eventually, that's not enough for eminent domain. At eminent domain, so they'll make this offer, and let's say you can't get a deal done and they're headed towards eminent domain, the broker's opinion won't work. In Georgia, there is called a landowner bill of rights, where a landowner is entitled to pre-condemnation requirements on behalf of the condemnor. One of those requirements is they have to appraise the property, and they have to issue an appraisal based on that, issue an offer based on that appraisal. So they'll issue the first offer that's probably not premised on an appraisal, and if deal can't be met, then they're going to do a condemnation appraisal. They will give you the opportunity to be there during the appraisal inspection, and then they'll issue you a new offer based off that appraisal that they did. And that will serve the purpose of, they'll be able to go to the court and say, look, we complied with all the pre-condemnation requirements, we did the appraisal, we made the offer, here's what it's based off. So you'll eventually have an appraisal. The first one will just be raw land value that they came up with. The second one will be an actual appraisal. Will they examine utility impact? No. They'll just say it's not a thing, or they found that there is no impact from the introduction of power lines to land value. So you'll have to do your own, at that point, do your own appraising if necessary to counter that. Does that make sense? Okay. And we'll take a couple more and then I gotta go. Yeah. So great question. Yeah, what do you do if you're an adjacent landowner? So let's say your property is not affected, as in they're not crossing it at all, but you're gonna be right next to it. You are in the worst possible situation. I'm sorry to say, the reality is that you want it on your property at that point. And I was talking with a landowner before we started here. They guided the line around her residential property. It's 50 feet from it, from the house, but it's on a neighboring parcel. And they did that on purpose because you're not entitled to compensation if your property isn't taken. Now, there is such a thing called inverse condemnation, where you file the lawsuit against them and say, you give me the money that you devalued my property to, even though you didn't actually come on my land. Here's the problem with that. Inverse condemnation cases, unless they actually touch your land, as in come onto it, are very difficult to win. In fact, to win an inverse case in that scenario, you need to basically say that my property is worthless. As it not that it's worth something, that it's not worth anything, or worth very little because of the power line. That is a very tough argument to make because of the power line. Not that it doesn't devalue, I agree that it does, that it devalues to the point that you'll have an effective inverse claim. It's infrequent, but it's parcel by parcel. We evaluate inverse cases on a parcel by parcel. If we see, an actionable claim, we'll let you know. So that's how that works, unfortunately. Okay, last question, yeah. I would agree it would. I mean, I don't want to live next to a power line, even if it's not on my property. The problem is that mere devaluation, if they're not on your land, is not enough. They need to be on your land so that you can get paid, so they have to pay you. They're not going to put a line next to you and then come to your front door and say, hey, we're putting something next door, but we feel really bad. Here's 600, they're not going to do that. So either you get them to put it on your property, which it sounds counterintuitive, but that's what we tell folks. If you're one of those people where it's close but not on you, maybe your neighbor doesn't want it on them, say, hey, bring it over. Let's do it. I'm going to be looking at it anyway, so you might as well get paid for it. So you don't, I hate to be blunt, but the worst possible scenario is next to but not on it. Okay, I do have to go. I apologize. Thank you, everyone, for having me. I appreciate it. If you have questions, my contact is up there. I think, do we have business cards? There's business cards. If you have questions, email me, call me. I don't charge for any of this. If you're curious about what's going on, I think we're going to send this presentation out too, so you'll have access to it. You'll have access to the handouts that I also put in the folder. Thank you for your time, and I hope it works out for everybody.